Excellencies, ladies and gentlemen, thank you very much. I'm very honored to be here. I note also that we are almost 1 hour delayed with the program, so I'll try to be as short as possible. Allow me just one tiny thing. The International Criminal Court is actually not part of the United Nations. It's separate. It has been created by an international treaty, and that's where we can say that the start is actually a result of a cultural dialogue. It was summarized yesterday by one of the Iceland judges in a wonderful way. He said, I have been all my life doing cultural diplomacy without even knowing that. And actually, it's absolutely true. When we are speaking about creating an international treaty that would establish an international tribunal, in our case, the International Criminal Court, then, of course, the negotiators of this treaty come with their own notions, with their own legal culture, with what they are used to. And they try to put it, in part because that's what they believe in, that's what they already know. They know that it can function, it's a good thing. But also it's part of allowing their own legal culture to shine on the international level. And then there are others who are trying to do exactly the same. Ultimately, an international treaty is a kind of a patchwork. It's a compromise between different legal cultures that are trying each to put some of their own notions. Now, in doing that, they will inevitably find sometimes that there are some dead ends to that. If we are putting a notion coming from one legal culture and another notion coming from another legal culture, then we will need to create something new to make them function together. If not, they will look as if they are opposed to each other. So, and of course the ICC, the treaty that created the ICC that we call the Rome Statute, it was adopted in Rome in 1998, was built also on the heritage of other international tribunals. The International Tribunal for ex-Yugoslavia, for Rwanda, Nuremberg, Tokyo. It has a long history behind it. But also there was something to be learned from the shortcoming of these previous experiences. For example, in the Rome Statute, in the treaty that created the ICC, there was an element that was added that did not exist in the previous tribunals, which is, what is the role of the victims? Can they have a voice? That comes from more of a continental legal culture rather than an Anglo-Saxon legal culture. But in the same time, they could not go all the way as in the continental level as to themselves starting the cases for criminal cases. So there was a role assigned to victims as something to compensate what was done on the previous experiences, the international tribunals, but also not going all the way where continental law would have went. So we are left with this international treaty that, as I said, built on previous experiences, come with national legal notions, but also had to be creative to add something to join all this together. For another example, the principle of complementarity. In previous international tribunals, namely Yugoslavia or Rwanda, there was a kind of supremacy of the international tribunal over the national courts. For the ICC, the International Criminal Court, it's actually the other way around. It's primarily the national courts. If they are not doing their part, they are not willing, they are not capable, then the ICC can intervene. This is something that did not exist before. It was added after. The notion of the role of the prosecutor. We have a prosecutor that can, in the same time, investigate and bring the cases before the courts. In some legal cultures, this does not exist. They have to be two separate functions. But once we decided that we want that, because there was a lot of states that wanted an independent office of the prosecutor that is strong, that does the investigations, bring the charges, then there was a need for a filter. So we created a new phase of the procedure that is called the confirmation of charges. So the prosecutor indeed investigate and bring the charges, but these charges don't go directly to a trial. There's first a chamber, pretrial chamber, that would consider whether to confirm these charges, so will act as a filter. And by doing that, they are shaping the charges that are brought by the prosecutor. This is a role for the judges that is not normally done in the previous experiences or in some legal cultures, like the Anglo-Saxon culture. So in that way, I could say that first, the ICC and the field of international criminal law in itself is a fruit of a creative cultural dialogue, not only coming with what we know, but also having to create something new. But it's also a space, a continuous space, where this dialogue is still happening today. Because, of course, we have this treaty. Then we have 18 judges that comes from all the different regions of the world, that represents all the different legal cultures. We have, by the statute, a gender balance that has to be observed. It's not equal, it's not equality. In certain moments, we had 10 female judges and 8 male judges. In other moments, we had 6 and 12 and so on. But in general, it's never less than the third. And when it was that, it was compensated by the fact that the president and the 2 vice presidents and the prosecutor were all women. So, but all these people coming from these different regions and different legal cultures, they will have to work together. That means that this cultural dialogue is still ongoing. On the same chamber, we will have a French judge, a Malian judge, and, for example, a Korean judge. How will all that function together? How will they do the interpretation of the Rome Statute? It's something that would require this dialogue to continue. And we could see that because in different cases, judges will play different roles, normally based on their interpretation of the statute, but also on how they normally used when they were on the national courts to interpret their own roles. So in certain cases, judges will be more willing to ask questions to the witnesses themselves, to call witnesses, to go on judicial visits to the location where the crimes has happened. In other cases, judges, using the same Rome Statute and not doing anything wrong in the interpretation, will be more hesitant to do that. They will leave the parties to bring the arguments, and then they will decide on what the parties have brought. So this kind of cultural dialogue is still ongoing. It's also reflected in the fact that the judges write and amend the regulations of the court. So we have the statute itself and a couple of other documents that were adopted by the states. We cannot touch them. It's only the states that change them. But the procedural aspects in certain elements, like can the judges change the legal qualification of the same facts? The prosecutor is bringing that this and this and this has happened in this village, let's say in Congo, for example, because we had already these cases. Can the judges say, okay, but this same fact that you are presenting to us as sexual violence can be actually qualified as slavery, enslavement? Do they have the authority to do that? This, in certain legal cultures, is acceptable. In others, it's not. And so they put that in the regulations of the court that they have created, and they agreed on it in terms of this, as I said, dialogue that they have ongoing. Not to be very long, there is also a third part of this continuous dialogue, I would say, which is that after the statute itself has been created on the international level, after judges have been elected and they started working on the international level, all this has repercussions after that on the national level. Because the states, when they are ratifying the Rome Statute or when they are inspired by the work of the International Tribunal, they have to domesticate, to put in the national legal system this international treaty. Normally they adopt laws, they change, they amend their criminal laws or create new laws to match this international treaty to which they have joined. And currently we have about 2/3 of the states in the world that are members of this statute. So by doing that, they are introducing into their own legal system notions that did not exist before, like the notion of war crimes or crimes against humanity or genocide that maybe were not codified in their legal system before. Maybe then they will be including things like the enlistment of children under the age of 15 is a war crime. Maybe the attacks against cultural institutions or against heritage buildings that have historical value, it's not considered just as destruction, but it is a war crime on its own. So there is new notions that can be introduced by that. I had also the honor to be in Tunisia at a certain time just after the revolution, where there were all the discussions about transitional justice and what would be the rights of the victims in this kind of environment, and can victims then have collective reparations and not only individual reparations? What kind of collective reparations? Then there was this role of inspiring by the fact that we have already some regulations and some laws and some cases that have been already put in place that they can look at, get inspiration, and adapt it to their own local environment. So this is also part of how this field of international criminal law is a fruit, but also is a place where the dialogue between the different legal cultures is still actually ongoing. And to end with a couple of words looking forward, I think that there is a lot of potential for cultural diplomacy, speaking from the legal point of view. So legal culture exchanges between people who have already had successful experiences in campaigning for modifications of the criminal law against the death penalty, for example, or for the ratification of some international treaties like the Rome Statute, like treaties for the protection of children's rights and gender equality and other treaties, to put them in contact with activists and legal experts in other countries to have this kind of exchange between them to learn from each other. I think that there is a huge potential, especially looking at countries that in our Rome Statute or in two regions that are less represented among the states parties to the Rome Statute, mainly in the North Africa and West Asian region and Southeast Asian region. There's not so many states that have joined the Rome Statute, and I think that by exchanging knowledge about really what is it about and how it is a field that is still being shaped and that everyone can contribute to the future of this field, I think we can achieve some good results. Thank you.
Thank you very much. I think again we only have time for one question, and it's your question.
Okay, thank you. Yeah, first of all, I would like to thank you, Mr. El Abdallah, for the excellent speech, and being also there, of course, you have a lot of information to share with us, and of course, it's with big interest to have it. But I think that, of course, the creation of international ICC, or International Court of Justice, is a huge success for international community. But I think that in some directions it's a weak court, let's say. Two reasons. Or the main reason, for example, is the absence of the United States. They were very active in the signing of the Statute of Rome, and then, but they don't ratify it, and we know the reasons and so on. Even some states have finished bilateral
agreements
with the United States, not to deliver potentially U.S. citizens in the court. And secondly, quite often the court is accused for having only some few cases, small cases for Africa, not being an international, but let's say for Africa cases. So, how do you see the perspective of the court on these two directions? Mm-hmm. First, to toward the United States? Because of course this dialogue you mentioned, cultural dialogue, it's very good, it's excellent, I would say, and also will bring more states ratifying the Rome Statute. But at the same time, the actual status, of course, brings a lot of difficulties. So you mentioned we have all. There are 18 judges, huge hundreds of prosecutors, but the results, I think, are not as wished.
Mm-hmm.
What can you say about that? And thank you.
Thank you, actually. If you allow me first to speak about the number of cases themselves, I think that there is already a large number of cases. We have 26, 27 cases currently. We have 11 investigations, and there are another 11 studies of whether to open other investigations as well. So for a court that is 15 years old, it's not a bad result, specifically that it is a court that is built on the principle of being a court of last resort. So built on the principle of complementarity. So what we want is actually to incite as much as possible the local authorities and the national tribunals to do their own part. That would be our most successful strategy, and to handle only the cases where there is no will or no capacity to handle them. So we don't tend to measure our own success by the number of the cases. In the same time, I note that we have 15 suspects that are at large. But it is not the ICC responsibility to arrest them, it's the state's responsibility. So when there is a failure to arrest them, we need to see who was actually in charge of arresting them. And to solve that, we need, I think, more cooperation from the states, and this cooperation we can get there only by more knowledge, more dialogue, more building support from the states and understanding from them that the court is not undermining their sovereignty. It's quite the opposite. It's empowering their sovereignty because they can decide on joining or not. And by doing that, they keep the primary responsibility over their own cases. So we are only there to support where their own cases cannot go ahead. So that's one element. The second element is related to the United States specifically, but we can say the same about Russia, China, and some other countries that are not states parties to the Rome Statute. I don't think that by not having an ideal world, we should stop fighting for getting there. Of course, we are not in an ideal world. We don't have all the states that are parties to this statute. And originally, it was decided to be created by a treaty and not as part of the UN, allowing every state to decide themselves if they want to join it or not. Ultimately, I hope we will get to a moment where we will have a universal jurisdiction. But in order to get there, we need more and more people that believe in the need for international criminal law and international criminal justice, and to accept that we cannot use the argument of sovereignty to shield our own soldier or our own people from being accountable for what they are doing. Accountable first before the national tribunals, but if not, then before an international tribunal. And I think that in a lot of the arguments that we can read sometimes in some statements, whether in the United States or in others, there is some misunderstanding or misperception of these fundamental principles. And I know a lot of NGOs, the American Bar Associations and others that are trying very hard and working inside the United States and others in other places to bring the correct information to start with, to correct these misperceptions, and hopefully when there will be enough support among the people, then this support will go to the governments at certain time. For the time being, the court continues its own work where it has jurisdiction. Like any court, we have jurisdiction in certain places over certain criminal acts, but not over everything and not everywhere. Now, for the third element of your question, which is why the court was focusing mainly on some African cases. I see the ICC as part of a whole international criminal tribunals network. The ICC is not just the only international tribunal that existed. There has been others, like the one for Rwanda, like the one for ex-Yugoslavia. And if the court, if the ICC was existing at the time of the Yugoslavian conflict, maybe there will have been non-ICTY, but the ICC would have handled that, and then maybe the first cases would have been European. But the court entered into activity in 2003, after a certain amount of conflicts have been already dealt with by other tribunals. And it has specific mandates that, for example, we have no mandate over Syria because Syria is not a state party, and there's no high-level officials from state parties that are allegedly involved in committing mass crimes there. But where the court has jurisdiction, then, which means in the countries that have ratified the Rome Statute, or if their citizens are committing crimes anywhere in the world, the court is active. It can be activated by three ways, either at the request of the Security Council, and Security Council used that only twice for Libya and for Sudan. So it was not the ICC choice, it was the Security Council choice. Second way of exercising jurisdiction is at the request of the states themselves. And until very recently, with the Palestine referral and with the referral of Latin American states regarding Venezuela, we had only referrals from African states themselves. So again, it was their own choices. Where the prosecutor can decide on her own initiative to open an investigation, she has already decided with regard to Kenya, to Ivory Coast in Africa, but also to Georgia, which is not an African country, of course, and she has also decided about Afghanistan. And she is already considering, as I said, in preliminary examination, whether to open an investigation or not in relation to Ukraine, Palestine, Colombia, Venezuela, and so others. So historically speaking, the first cases before the ICC were focused on Africa because of the African states themselves asking for that and because of Security Council asking for that. But where we could, on our own, start investigation, we were not limiting this investigation to any particular region. Thank you.
Thank you very much.